Okay, Danny, whenever you're ready, I think if people want to join, they can join after,
Okay.
or they can watch it recorded. I don't think you need any introduction because I think everybody here should know you by now.
Yeah.
Yeah.
Might not hurt to quickly reintroduce because I do think it's been a little while.
Okay. Do you want to do a self-introduction, Danny? Then?
Yeah, I can do it quick. What about the PowerPoint? Are you able to put it on or no?
Let me see if I even received it. I got your PowerPoint. Yes, you should be able to share your screen if you put it up on your screen.
How do I do that?
If you roll your mouse over your Zoom screen, there should be a little green button saying share screen at the bottom.
Roll my mouse where?
Oh, anywhere in your picture where you see yourself. Or,
Oh, okay.
It says screen share on the bottom of the prompts.
yeah. You see it?
No. That profile. There we go.
You see it? Okay. That was me sharing. You found it? No?
I don't have it. I don't see it.
Okay, I will let me do this screen share then.
Okay.
Hang on.
Oh, I found it. Share screen. Got it.
Oh, cool.
Got it.
Oh, good.
Okay. Okay.
There we go.
To explore all apps. Okay, I don't know what happened. Now it says it's gonna be a bunch of different apps.
I can see your screen now.
Oh, the PowerPoint's up?
Yes.
Oh, okay, good.
Yeah.
All right. Let me enlarge this myself.
So, but if you could do a short introduction, if not I think everybody should know who you are, but anyways, just.
Okay. Well, good morning, everyone. My name is Danny Villazon. I've been an attorney since 1992. I went to Florida State. My primary practice is representing realtors and appraisers before the Florida Real Estate Commission and the Florida Real Estate Appraisal Board. I also represent a couple of local realtor associations. Currently, I am the board attorney for the Greater Tampa Association. I was special counsel to the Orlando Regional Realtor Association, and I'm also currently the board attorney for the Osceola County Board of Realtors. I worked at FREC from 1994 to 2000. I was the chief prosecutor there. I also served as legal counsel to the Florida Real Estate Commission. What I'm going to try to do today is give you a brief update as to what's going on at FREC and what to look out for, so you don't have to ever hire me to represent you before FREC. Okay, these statistics are a little dated. They're probably more now, but average FREC is receiving 322 complaints a month. They opened out of those 322 complaints, 88 investigations, and they currently have 34 investigators. This really needs to be updated because it's been crazy the last year on the amount of people who are applying for a real estate license. This has probably gone up probably 50,000 more licensees, but there's a total of 424,576 real estate licensees, 215,000 active sales associates, 21,000 brokers, and 41,000 active, broker sales associates and 41,000. I would easily suggest that those numbers have gone up by 20%. In 2011, FREC started a random audit where basically they'll just randomly come to your office and look at your files to make sure you're in compliance with FREC rules and and maintaining appropriate files. What they're looking for are escrow issues, which you guys don't have to worry about since you use a title company. It's more the broker's responsibility to make sure they're doing proper reconciliations if they hold trust funds. Unfortunately, Ben, from my understanding, you guys don't have trust accounts, so it shouldn't be a problem.
Actually,
Right, this is important. This
Danny?
is what statute says, what you need in your files, and all the sales associates are responsible for this also. It doesn't give you a specific list. It basically is a catch-all. It says that everyone should have in their records sufficient documentation to show you're in compliance with the FREC rules and statutes. So there's no general list. They're going in there and they're checking certain things. This is what I recommend should be in your sales file, because when they do an inspection, they randomly select about 10 to 20 files and go through the files to make sure that you have these things in your files. You should have a fully executed contract. You should have all pages of the contract. Real important, they always check this, that you have the escrow verification letter. We've been having issues with this recently. Proof you provided inspection reports and termite reports to your buyer. Proof of disclosing all known facts that materially affect the value of residential real property and are not readily observable to the buyer. I have a case right now where my client was the listing agent, received an inspection report that showed all kinds of problems. The transaction failed to close. A few days later, he had another buyer put an offer on the property, but he didn't disclose the previous inspection report that there were serious leak problems. And after that buyer bought the property, they found out that there was an inspection report that showed that, and they filed a complaint against him for the Davis versus Johnson, because absolutely he had knowledge because he had the previous buyer's inspection report and didn't disclose it. So it's going to be a problem for him. Proof of deposits timely made in compliance with contract terms. We see a lot of that. Everyone's real good about getting the initial deposit, but you definitely have to have some kind of system, some kind of calendar system where you make sure you collect the second deposit if any is required, because that can be considered a breach of contract. So it's very important, if there is a second deposit that needs to be made, that they timely make it and you inform all parties that the deposit has been made. Listing files. They're always looking for a fully executed copy of the listing contract. I suggest that you go on public records and make sure you're signing the listing with the owner of the property. I've seen lots of situations where people have entered into listing contracts and it turns out that the person they're listing with is not the owner of the property, or two, it's a husband and wife, and the husband doesn't want to sign, doesn't want to sell the property, so the agent gets the wife to sign it, does all this work marketing the property, and ultimately the husband says, no, I'm not going to sell. The listing agent gets a buyer, it's ready to go, and the husband refuses to sign, and you just wasted all your time because you can't force him or her to sign. And especially since they're not a party to the listing contract, you can't sue them either if we're not going through with the transaction. So it's very important. I tell everyone, go to the public records, find out who the owners of records are, and make sure you have the proper signatures. Same with if it's a corporation, that you have the proper authorizations in regard to the person who is signing the listing agreement has the authorization. Same with LLC. So very important. You don't want to waste your time marketing a property and find out you can't sell it at the end. I recommend in all files, if necessary, phone logs, document everything, emails, and the FREC has held that files can be stored electronically as long as a hard copy can be printed. And I'm of the philosophy, the more documentation, the better. One issue that we see a lot, especially around renewal period, is you need to make sure that all the licensees have that your license is valid and active and current. It can go involuntary and active and they won't tell you. If, for example, you didn't pay your renewal fee, they'll just make your license go involuntary and active and you won't know. If you didn't do your continuing education, your license will go involuntary and active and they don't notify you. It just goes inactive. And there's a couple problems with what happens if you're operating with an inactive license. One, any contract you made is void. So you may lose a commission because you didn't have an active license. 2, you can be charged with operating within an active license and lose your license that way. I know some listing agents who specifically have a practice of checking to make sure the cooperating broker had an active license at the time they procured the buyer. And if they don't, they keep the commission for themselves and refuse to pay the cooperating broker commission because that sales associate didn't have an active license at the time. And it could have been something as stupid as not paying your whatever the renewal fee is. So very important that you go to my Florida license, you're able to check the status of your license. And usually this happens around March and October during the renewal cycle. So double check to make sure your license is in good standing. I am shocked how many times it happens that people don't realize that their license is inactive. Most common FREC, it's the same old story, failure to timely disclose criminal history, regardless of the crime, if it's a DUI, misdemeanor, or a serious felony, regardless of if adjudication was withheld or not. If you enter a plea or are found guilty, you need to notify FREC within 30 days. It depends on the type of offense. Usually if you notify them within 30 days and it's a minor offense, nothing will really happen. You get into serious trouble when you don't notify them and somebody finds out. I've had a lot of cases where a boyfriend or girlfriend or a competitor knows that their competition had a DUI and they anonymously report it to FREC and the case gets opened against them and it's a real mess. And it happens more than you think. We've had lots of those cases where and they can open up an anonymous complaint where people are telling on each other, trying to get a competitive advantage. And the problem is that if you get a discipline action against you and it becomes a final order, it's a public record. So your competition can say, oh, don't list with so-and-so, look at his disciplinary history. He's a criminal, he was charged with not telling us about his crime or something like that. So it's very important that you keep your records, your record clear. And the sad thing is it's there forever. It's very difficult to have that removed. So if you have, I hope it never happens to you, but if you ever have any issues, make sure you report it to FREC. Mostly escrow issues, hopefully doesn't involve you, but what we see a lot is, it's amazing to me that the real estate schools don't go too much into property management, but a lot of people don't realize that rentals, any rental proceeds you collect need to be held in escrow because you're holding that money for the benefit of someone else. And usually that is the biggest issue we see. There have been some very big property management companies that their license had to get an emergency suspension order because they were short literally in the hundreds of thousands of dollars. They were holding lots of money and they were using the rental proceeds, robbing Paul to pay Peter, and they wound up with a mess and ultimately they had their licenses revoked. I always recommend, and I think your firm does this, always use a title company. There's only one rule if you use title company. They instituted these rules some time ago, but a lot of people are not familiar with it. It's 61, it should be J2, 14.008. If you are the person that prepares the contract, you have an obligation within 10 days to get an escrow verification letter. And then you must provide the seller's agent written verification of the deposits made or not made. And that includes additional deposits. So just remember as a rule of thumb, if you write the contract, you need to indicate the name of the title company, the address, and you also need to have the escrow verification letter in the file, verifying that the funds were made, and give that to the listing agent. If you don't, and if the buyer did not provide the escrow, you need to notify the listing agent also, because technically it can be considered a breach of contract and the listing agent needs to be able to tell their seller what they want to do. So very important that you communicate the status of the deposit. That is one way to quickly lose your license, is not doing that. I've seen it happen a lot of times. People just forget, or they're just so excited to get the deal that they're not following through and they don't notify. Ultimately, the buyer backs out, the seller wants to claim the deposit, and there's no money. So very important. Also, if you don't collect deposits, if you're the escrow agent, it will create shortages in your escrow account, breach of contract, and always notify the listing agent in writing so you have it well documented in case they accuse you of not telling them that the additional deposit wasn't made. Also, deposits must be made within 3 business days. Again, escrow property management, failure to place security deposits and rental proceeds in an escrow account, failure to account and deliver to a seller. It's really a landlord. A lot of times, landlords want to see receipts. They want to find out what's going on with the money. And you, as a licensee, if you're doing property management, have an obligation to account to your client, to the landlord, exactly where the money went, where the rental proceeds went, where where you spent money for property repairs and things of that nature. A big problem I see out there is a lot of sales associates are doing property management on their own and not notifying their broker, collecting rents and making repairs and not running it through the broker because for some reason their broker doesn't do property management. They want to do a favor to one of their clients that they help purchase a property and start getting into the business of property management. This used to happen in short sales. I bet you it's happening now. All offers not being presented to the sellers. You have an obligation as a transaction broker, a fiduciary duty, to present all offers to your seller. What we've been seeing is a lot of listing agents haven't been presenting all offers because usually either one, they want both sides of the deal and they have their own client that's making an offer on the property. So they're not presenting your offer. That is a violation. They need to present all offers to the seller. It's hard to prove because you as the cooperating broker don't necessarily have contact with the seller. But you can always ask the broker for the listing agent for confirmation that your offer was presented. And usually what I tell people to do, make sure you present all offers and have the seller sign if they're going to reject the offer. And don't throw that contract away if the deal doesn't get done. Keep it in your file just in case someone filed a complaint against you for failure to make an offer. You can show in your file that you have a copy of that contract that was canceled where the seller signed off rejecting the offer. So that's why it's very important to keep all documentation. A lot of times, a lot of agents, if the deal didn't go through, they throw that contract away. So you need to keep that in your file. I just went over this. I don't know how much short sales are going out right now, but in the past, I told people to keep detailed notes in the equator to show they can have proof that they presented the offer to the bank, and always get return receipt. Be careful with mortgage fraud. If it sounds too good to be true, trust your instincts. If the hair on your back, raises, don't do it. I've seen all kinds of wild, deals, especially back about 10 years ago during the whole fiscal crisis. People usually don't walk away when buying a property with cash. They usually come to the table with cash. So you got to be careful of those types of deals because you can be charged with aiding and abetting mortgage fraud. And it's the worst case scenario. You don't want the FBI knocking on your door saying you assisted in mortgage fraud. Unfortunately, I've had to visit quite a few licensees at the federal prison who got involved in these mortgage fraud schemes back during the mortgage crisis. They didn't make any money. They were just a pawn in the whole transaction. But they got caught up and were charged with conspiracy to commit wire fraud, which is mortgage fraud, and they wound up in prison. And a lot of them lost their licenses as a result. There's also, I'm not sure how they do it, but there's manipulating sales prices on the MLS. And a big issue, I've had quite a couple clients wind up in prison because of this. Buyer incentives not disclosed on the HUD. Paying the buyer outside of closing, which is always an issue. This is a big issue with FREC nowadays, advertising. They're going around, especially during the COVID crisis. They weren't out in the field, so they were going on the internet, checking everyone's advertising. You need to be careful of agent branding. The agents can't have their own brand. The name that's on the website has to be the name registered with FREC. So you have to have the name Maxim on all your advertising. And they indicated it must be at the point of contact and in the same size as the rest of the text. I've seen some cases where agents, with the idea of branding themselves, put the name of the brokerage in real tiny font on the bottom. That's a big problem. You cannot do that. It has to be the same same size as the other font in the property. This is the newest rule and the biggest issue, team advertising. FREC allows team advertising, but they have certain rules that you have to follow. The number one rule is there's certain terms which is on this list, and anyone that's if you want it, you can have a copy of this PowerPoint. But this is the list, this is the rule. These are the words you cannot have in your team name. You can't be, Maxim and your team name be something that has the term agency, associates, brokers, things of that nature. In addition, as I spoke, you have to have the name of your brokerage in that team advertising. And FREC is really cracking down on this. This is something that's relatively new. It was kind of a compromise that they allow these teams to do their advertising, but there's certain procedures that have to be followed when using the team name. And you need to make sure that your broker approves it. Referral fees, you're allowed to pay a referral fee as long as the person is licensed and they cannot perform real estate activities in Florida. If you're getting a referral, someone from England, that's fine. You can pay them a referral fee as long as they're properly licensed in England to sell real estate. If they have a license rules, I don't know. Moreover, they can't come into Florida and start conducting real estate activity. They can go with you to an open house, but they can't go and register someone at an open house. You have to be there. You have to be the person doing that. So there's two things they look at. One, that the person is properly licensed wherever they're from, and two, that they perform no real estate activity in Florida. Unlicensed assistants, FREC used to have, and they don't have it anymore, a list of things that unlicensed assistants can do. They've done away with that list because they're not 100% sure whether they want them to do those activities. So just be careful of how you use unlicensed assistants. FREC has set up sting operations in the past. Cold calling issues. I know it happens a lot because a lot of people hire these third parties to do cold calling to try to solicit listings. FREC has frowned upon that. They indicate that as licensed activity because when you're calling a seller about selling their property, you're basically asking them for information about their property, and it can be considered aiding and abetting unlicensed activity. So you need to be careful with that. Dual employment, a sales associate can only work with one broker. You can't work with Maxim during the week and then on weekends, unless you have the listing, work at a builder's model home, unless Maxim is the listing agent there. So you can only have one person that you do real estate activities with. This is just for Bent. It's the broker liability. Everything your agents do, Bent, you're responsible. What I recommend to avoid issues with that you have a policy procedure manual, that everyone is signed by the agent, you have E&O insurance, and that you have independent contractors agreements. I'm always amazed that I get lots of agents that they want to leave their brokerage or they're in a commission dispute with their broker. And I asked them for a copy of their independent contractor agreement so we can see what the terms were, what the percentages were, and nobody has it. They said, oh, we just verbally agreed. So it's very important that you have it in writing, what the conditions are if you leave the brokerage, whether you're allowed to take the listings or not, what your commission split's going to be, what your commission split's going to be if you leave the office. You need to keep that documentation, have it all in writing, because if something does happen, the courts will turn to that document. That is your contract with your broker. So it's very important that you have those documents. LLCs and PAs for sales associates. This is more for tax purposes. The FREC many years ago wanted to give sales associates and broker associates the advantage of being incorporated, but they only allow you to incorporate in your name. You can't be XYZ LLC and have Bent pay that XYZ corporation a commission. It has to be the name of the licensee. And the reason for that is if you do XYZ LLC, that is not licensed. That is not a licensed real estate corporation. FREC will not issue that to a sales associate. That has to be a brokerage. However, they allow you to put Jane Smith LLC. It'll be licensed in that, and then Bent can pay the commission to Jane Smith LLC without being charged with paying an unlicensed entity a commission. So if you want to do that, and there's a lot of benefits to that, talk to your accountant, set up the LLC, I think it's like $25, and FREC will issue, DPR will issue a license that says your name LLC, or the Inc. or whatever, however your accountant wants to set up the corporate entity. This is I'm going to do this pretty quickly because hopefully you guys never have to deal with this. But this is the FREC complaint process. Complaint is very easily filed. Anybody can file a complaint. All they have to do is show legal sufficiency. And what we see a lot of, unfortunately, is licensees filing complaints against other licensees. And once that happens, the investigation starts. They also can open up a complaint based on a random audit. What happens is the complaint goes to a legal analyst in Orlando, and they determine legal sufficiency. Legal sufficiency is very basic. Are you a licensee? Is one element, and whether the complaint involves a violation of 475 or FREC rules. If those two thresholds are met, an investigation gets started, an investigator is assigned the case, and you are entitled to receive, you will receive a letter from the investigator indicating complaint has been filed against you, and they are required by statute to give you a copy of that complaint so you can file a response. Very, very important that you don't ignore it. Even if the investigator was super nice with you when they interviewed you and told you there was nothing to worry about, the case does not go away by itself. There's a certain process for the case to go away. Number one, you need to file a response to the complaint so they hear your version of events. Two, request a copy of the investigator's report to make sure that the investigator, when they interviewed you, correctly wrote down what you said, and if necessary, respond to the investigator's report. If it is a minor violation, technically they can give you a citation. The problem with citations, it becomes a public record. And like I spoke about earlier, if it's a public record, the public can see it. They go to your complaint history and they'll see a citation, and that's there forever. You want to avoid agreeing to a citation. I would recommend, if they're trying to give you a citation, you dispute it. The second thing the investigator can do is give you a notice of noncompliance. That's fine. That's confidential. It just says, don't do that again, and you're done with that. And there's a whole list of violations that are considered notices of noncompliance or resolved by citation. If there's a complaint, it has to go to the legal section. That's what I'm telling you. It does not go away by itself. It has to go to an attorney in Tallahassee to review it. And basically, the attorney in Tallahassee has three options. One, which I always try to get, dismiss the case outright, and we're done. You get a letter saying the case was dismissed and it remains confidential. You can see a pattern here. We want everything to remain confidential. Two, the attorney can dismiss it with a letter of guidance. Again, that's okay. We want it to remain confidential. The case is dismissed, but it's still confidential. And when I say confidential, that means nobody knows about it. It never happened. It's not in your records. There's no record of it. The public can't see it. The third option, which we want to avoid, is the filing of a legal administrative complaint against you. And basically what that is the attorney feels that you violated the FREC statutes. They're going to allege the facts that you did to violate that statute and formally charge you. That decision by the attorney has to be approved by the FREC probable cause panel. And the sad thing is, if there is a formal complaint filed against you and the FREC finds probable cause, it becomes a public record. It is on your file forever. If a formal complaint is filed against you, you basically, again, have three options. One, you can dispute the facts and request a formal hearing before an administrative law judge. At that point in time, you're telling DPR they have to prove their case by clear and convincing evidence. And basically, it's kind of like a non-jury trial. You go before, it's a bench trial. You go before a judge, and the judge hears the case. The state is prosecuting the case. They're going to put witnesses on to prove that you violated the statute, and you have the opportunity to cross-examine those witnesses, and you have the opportunity to put your witnesses on, and then both sides argue to the judge why you're guilty or not guilty. The second thing, which I don't recommend, is that you commit the factual allegations and let FREC issue a penalty. And I've seen part of the reason I got in this business when I was a legal counsel, I used to watch people do that all the time and leave with their license revoked. You don't know what the commission's going to do. They may feel strongly about certain issues. And I know all licensees think they're great salespeople and they can convince the commission how great they are. But I saw it so many times that people would go in there thinking they were going to make a great argument to the commission and wound up with their licenses revoked and permanently revoked. The third option, which happens a lot, most of these cases settle because if they do file a formal complaint against you, they usually have evidence that you did something wrong. So it's called a stipulated agreement. Usually I like to get language in there whether you neither admit nor deny the allegations. There's agreed upon sanctions. So you don't leave there with your license revoked, but ultimately FREC must approve the sanctions. Finally, if everything goes wrong, you have the right to appeal the case before the District Court of Appeal. Clean slate, I think they need to extend this a little bit more. Certain minor violations can be wiped from your record after 2 years, but it's very rare that this happens, and it's very limited in what can be cleaned from your record. Most of the time, your record, if you ever are found guilty or receive a citation, will be there forever. If an investigator contacts you, first let Brent know, because Brent can call me and I can tell you what to do and we can hopefully resolve it immediately. But I always say you have to give them everything, but you give them only what is requested. Have procedures in your office so you know what to do if contacted by an investigator. If you're a sales associate, you shouldn't be talking to the investigator alone. Remember, you have due process rights. They can't bully you. They can't tell you have to come to my office on this day or else. They can't do that. I always say we must cooperate, but not immediately. And give yourself time to get the information ready and to formulate a response. These are some helpful risk reduction tips that over the years I've talked to insurance carriers that these are the type of things that they give out in order, policy procedures. Insurance carriers always obtain a written seller's disclosure. Never fill that out yourself. Never act outside the scope of your expertise. Don't start giving zoning advice and things of that nature. Follow pre-established office procedures. Disclose all conflicts in writing. If, for example, you have a relationship with the buyer, you need to a familial relationship with the buyer, you need to disclose that. If you are, if you have interest in the corporation that's buying the property, you need to disclose that. Familiar yourself with fair housing laws. That's a big issue. If not sure of something, always ask. You can always ask Bent. I know he's always available, and I'm always available to Bent, so we got you covered. If you have a question, just let us know. Know the Realtor Code of Ethics. Recently, there's been an uptick in those type of cases, lots of ethics complaints filed. Very important that you know that. And avoid overstated adjectives. I didn't make that up. That was the insurance company. Something to the effect, this is the most luxurious house in the neighborhood, things of that nature. You need to avoid that. Fair housing issues. Avoid using words and phrases in a discriminatory context in conversations and advertising. Never work with a discriminatory buyer or seller. Just tell them you're not interested. Equal service to all. This came up a couple months ago. Love letters. That's an issue where buyer's agents are having their buyers write letters to the listing agent and to the seller saying how much they love the property and their family would be great in it. Sometimes they say to the effect like, we'll enjoy our Christmas holidays in your beautiful house and things of that nature. And for some reason, that's been interpreted as a possible fair housing violation. So I recommend not giving love letters. Procuring cause, always a big issue. I'll go over this briefly. There's no predetermined rule of what procuring cause. A lot of people are under the misunderstanding. I introduced the buyer to the property. I'm entitled to the commission. It's more than that. It's based on the facts and circumstances, every case. Just introducing a buyer to the property doesn't necessarily mean you're the procuring cause. There's a long, complicated definition, which is in the PowerPoint, which I won't go over. But basically, what they're looking for is 3 phases. 1, you introduce the buyer to the property. 2, you represented the buyer throughout the transaction, the negotiation of the contract, the setting up the inspections, helping them get the financing, the appraising, and then finally, you were with the buyer at closing. If you can demonstrate those patterns, those activities during the transaction, usually you'll be awarded the procuring cause. Not always, because it goes to arbitration, you never know what's going to happen. But I strongly recommend you make detailed notes, keep your emails with your buyer to make sure you protect yourself with your commission. There's been lots of cases, and we call it buyers behaving badly, where the buyer will use you to go look at properties. They'll spend your whole weekends taking them to find the houses. And then once they find the house they like, they dump you and they go with their uncle who has a license, who's promising to give them a rebate, and the uncle gets the commission. A lot of times we can go to arbitration despite what the buyers wanted. We can prove that you were the procuring cause and entitled to the commission. So it's very important that you keep accurate records. Usually the evidence I receive in these types of cases are either emails or text messages between the buyer and the agent. In arbitration, the standard of proof is preponderance of the evidence. I've had 2 recent commissions where we won. One was for $55,000 for the selling agent, and the other one was for $68,000 for selling commission. And in those cases, the buyer testified that they didn't want to use my agent, that they fired my agent. But the panel said, I don't care. The agent did everything they were supposed to do, and they are the procuring cause, and gave my clients the commission. Just remember, the buyers do not determine procuring cause. It's the procuring cause panel, the arbitration panel does that. These are factors to be considered. Introduce buyer to the property, that's just one element. Subsequent efforts. They also look to see whether there was an estranged relationship, that you and the buyers didn't get along, and the buyers basically felt that you were not acting in their best interest, that you abandoned the buyers, you took them to see the property, but you didn't answer any other questions. They also look to see if there was intrusion by another agent, whether another agent, like the listing agent, tried to intrude on your relationship with the buyer, and whether the buyers froze out the broker, froze you out in order to get a better price. In that scenario, what happens is you're representing the buyer. The listing agent tells the buyer, well, if you use me, since I get both sides of the commission, I'll be able to reduce the price because I'm going to take a less commission. Therefore, the seller will net more, and we'll just keep this other person out. They can't get away with that. One of the arbitrations I had, the $55,000 one, that's what the listing agent tried to do, and ultimately the arbitration panel awarded the commission to my client. Again, keep detailed notes. And basically what I tell people when we go to arbitration, be prepared to tell the arbitration panel your story, what you did to earn the commission in this deal. Ben knows about these. The ADA compliant website. From what I understand, that's kind of died down. NAR got pretty involved with that and sent a letter to those people. And I haven't seen too many of those cases anymore with the ADA compliant website. Also, be careful with the tenant criminal history. You cannot deny someone ability to rent the property and you can't ask about their criminal history. You have to be very careful with that. All right, that is my presentation in 44 minutes. Does anyone have any questions or want me to elaborate on any of the issues that I brought up? No? Can you hear me?
I know if yeah. If you can does anybody have any questions at all?
I did a good job.
Yeah, I think as you mentioned initially, Danny, if we could get a copy of this, even just to reiterate to everyone, they can kind of have it on hand for them.
Yes.
It's not a bad thing for everyone to reference back to from time and time again, if not at least just reading it themselves one time thoroughly.
I agree. I have it, so I will distribute it today. Yeah. Yeah, Danny, we actually do have, we have rental escrows now. I was trying to mention that in the beginning. So we do not take escrow money for sales transactions, but we have rental and security deposit escrows.
Yeah, those, you have to reconcile those accounts and you have to make sure you collect them.
So, and we do also have, everybody does have an independent contractor agreement. At least every agent does. I know that Sam, our transaction coordinator, doesn't have one yet. She's only been with us about a year now, but still. But other than that, everybody does have an independent contractor agreement, and we also have distributed an office policy. But I never actually asked people to sign off on they received it. So I noticed that you recommend that we should do that.
Yes, so the agents attest that they agreed to follow the policies and procedures.
Well, they do that. They do that in the independent contractor agreement.
Yes, yes. I think it's in the independent contractor agreement that I know it's in the contract that they affirm that they'll follow FREC rules and statutes. I don't know if it references
office policy, and they've been giving a copy of the policy. So should we also request that everybody signs that copy?
You might, just so you have some acknowledgement that they were given it and they agree to abide by it. Yes. Because that protects you in case someone says you failed to supervise. You can say, no, they were given a copy of the policy and procedures. They signed off.
Okay.
Procedures. And usually they get themselves in trouble by not following the procedures.
Yeah. Okay. So.
All set?
It seems. Nope. No.
All right. Well, everyone, Bent knows where to find me. If there's ever an issue, I'm always there for you guys. Just let me know.
Okay. Well, thanks, Danny.
Hope you never need my services.
Thanks, Danny.
Thanks so much, Danny.
Thank you, Danny.
Really appreciate it.
All
Bye.
right. Bye-bye.
So. I'll see if I can. I'll kick him out. He probably doesn't mind. There we go.
I was like, and they've been dropping like flies though.
Okay,
Since
so
Danny signed off.
do we have anything else we need to talk about? What's I can't remember what's on next week. David Knox.
David Knox next week should be Jay the following week, which is the 14th.
Mm-hmm.
And then we've got that North Star Builder on the 21st.
Okay.
So, yes, sir. But yes, the next few weeks are packed. I don't know if anyone has any questions or needs help with anything, but it seems like they're all logging off pretty quickly.
I can see that. People quickly leaving, moving on with our lives.
Yep.
Well, if nothing else, we'll see everybody next week, hopefully. Okay.
All right, awesome. If you can get the recording out, that would be fabulous.
Yeah, I have the recording, and I'm actually almost done editing the one from last week, so we should have that up shortly, hopefully.
Awesome. Well, thanks everyone for your time, and hope you guys have an awesome day.
All right.
Thanks.
Bye.
Yeah.